court pleases.
They decided against President Convent.
Of Cliptic Hofmeyer, we are, as we did last year, are offering a bursary to all four of you, both of the...
In the matter between Cara Williams and St. Teresa Private School for Girls, the Constitutional Court of South Africa, Honorable Justice Motogane, Justice H, Justice Amir Mia, with Honorable Justice one of the State and presiding. You may be seated.
As it pleases the court, I am Clara Marie and I will be speaking first. I appeal with Ms. Rankin.
Okay, please let's hear from the respondents and then you can tell us how you're going to divide your time. Thank you.
As the court pleases, I am Chandra Smith and together with my co-counsel Caitlin Chetty, we appear on behalf of the respondent.
Thank you. Yes, Ms. Macheke, then you can come and explain to us how you're planning to do it.
I will be speaking for 10 minutes, my co-counsel will be speaking for 7 minutes, and reserve 3 minutes for rebuttal.
Thank you. Then please proceed.
Honourable Justices, this concerns the protection of a young appellant's inalienable and central rights of dignity and equality. Would your Justices find a brief summary of the facts helpful? Or
Asking me a question? Sorry, I didn't hear.
Sorry. Would your Justices find a brief summary of the facts helpful, or may I proceed?
We have read the documents, we know the facts, but if you need to summarize them for the purposes of your argument, then please do so. You don't ask us questions, we will soon ask you questions. So use your time to the best of your ability.
I will be presenting the first two issues in this matter, the first regarding the infringement of dignity, equality and freedom of association, the second regarding the promotion of Fair Discrimination Act 4 of 2000. My co-counsel Ms. Rankin will be presenting issue 3, which regards the role of a code of conduct and the infringement that the code of conduct has breached within this case. I would like to begin on issue 1, if it pleases the court. This issue 1, briefly to summarise it, proves the limitation of the appellant's right to dignity, equality and freedom of association by the respondent are not justified under clause 36 of the Constitution. Before I begin with my first submission, I'd like to contextualise the case a little bit. Firstly, we'd like, as the applicant, to put forward that the homosexual community is a minority. It was said in the National Coalition for Gay and Lesbian Equality versus the Minister of Justice that gays and lesbians are a permanent minority in society, suffered from patterns of disadvantage. Because they are a minority unable on their own to use political power to secure legislative advantages, they're exclusively reliant on the Bill of Rights for their protection. I will be talking firstly about how the school perpetuates the disadvantaged community within this case. My co-counsel will be dealing mainly with the second issue of it. So, because the court has also recognised that they are a minority and have tried to enact changes to be able to protect this minority, we, as the applicant, put forward that the respondent in this case must follow the patterns of what the court has been doing and follow the court's example in protecting this minority who've suffered so much from oppression. Again, we use the Furry case, which changed the word spouse for the protection of this minority. My first submission deals with dignity, which is section 10 of the Constitution, which states that everyone has inherent dignity and the right to freedom of consciousness, religion, belief, and opinion. In this case, the respondent, the school in this instance, is not affording the same rights to homosexuals. Within this instance, the school is not affording the same rights to homosexuals as they are to heterosexuals, and this perpetuates the detrimental cycle of oppression that has been placed on this community already. What it does is it creates a perception towards the applicant in this manner. It creates the perception that they're wrong and that homosexuals are not equal and do not deserve the same rights and freedoms as the heterosexual community. And as the applicant, we say that this could possibly cause psychological harm because she is at such an impressionable young age. What will happen at this time is that as she grows up, she will still continue to suffer cycles of oppression, and the school encourages cycle of oppression instead of protecting her.
Shouldn't we look at the nature and extent of this limitation? Is it not a once-off thing? I mean, if Kara does not attend this matric dance, what is the worst that's going to happen to her?
We submit that psychological damage comes on Kara because of the perpetuation of the cycle of oppression. We say that the limit is extensive because under no circumstances can dignity ever be limited, because it is the basis of a human being, because it is the cornerstone of our Constitution. We say that...
Okay, my last question.
Yes.
Remember, she's saying she's bringing this partner of hers so that she can see the reaction of her schoolmates.
We submit, my Justice, that this comment can be interpreted in any number of ways. The applicant may have just been so excited to see her partner because her partner might have looked absolutely stunning in her dress fitting.
Thanks. Let me not take most of your time.
Thank you.
Council, if I may ask you just on the last point, is it relevant that this is a private school? Will your argument be different if it's a public school? Isn't there an argument to be made that communities have the right to, on a private basis, form their own schools according to their own values, and that the national policy on religion and education of the country provides that in such a case they must avoid racial discrimination, but it doesn't say anything about any other kind of discrimination? That seems to indicate that some, what one may see as discrimination, may be allowable in a private school that may not be allowable in a public school.
Firstly, we submit that in accordance with Section 2 of the Constitution, all contract law, all law must be based within accordance of the Bill of Rights. And secondly, we say that once a private school is joined, you do not opt out of the system and you're still obligated to follow the same rules and the same Constitution as a public institution. I'm sorry, my Justices, my time is out.
I'll give you 1 minute to wrap up, to add anything that you would like to add.
Thank you. I would just quickly like to analyse Section 36 of the Constitution because I feel like at this moment this is the limitation we need to prove that it's not justified with this instance. Firstly, in subsection A of this Section 36, under the nature of the right, and we say that dignity is a cornerstone of the Constitution and it cannot be limited. We say that the right is inalienable. Secondly, we say that there is no need to limit the rights because as an openly gay...
Are you saying that the right to dignity cannot be limited?
Yes, Your Justice.
Are you rewriting the Constitution, or do you read the Constitution that way?
We refer to a table within the Constitution that states that dignity is an inalienable right and therefore cannot be limited within this instance, Your Justice.
Which rights in the Constitution are not inalienable? Which ones can be alienated, if that's the word you use?
Equality can be alienated, and within our argument we say that equality, the limitation placed on equality was not just in this instance.
Yeah, all right, just finish your submission so that you can feel comfortable.
Thank you, Your Honour, Your Justice. We say that there's no need to limit her right to her privilege to go to the dance, her freedom to go to the privilege to the dance, because as an openly gay student, there is no indication in the facts to say that she has been under such teasing or within the school, and we say that there's no repercussion that will fall on the school because she doesn't actively stop them from participating in their religion, from believing in God, from praying, from reading in the Bible. And then under subsection C, we say that the extent is extremely harsh because it does inflict on dignity, freedom of association, as well as equality. And under subsections E, we say that that this is the most restrictive means, and the school did not need to place this limit on the applicant within this manner.
What less restrictive means were there?
We say that because she doesn't stop the school from actively participating in their religion, she doesn't infringe on the school in any way, we say that her allowance to go to the dance is the less restrictive means within this instance.
Thank you.
Are
you done?
Yes, last sentence.
Yes.
I will now hand over to my co-counsel, who will analyse the Promotion of Fair Discrimination Act and her second half of the argument. Thank you, if it pleases the court.
Ms. Rankin? Remind me how much time you have?
My Justices, I have allocated myself 7 minutes of this court's time. My Justices, I have 2 submissions to make in continuation of the applicant's appeal against the respondent in this instant case. These submissions ultimately deal with the supremacy of the Constitution, and that in this case, the school's code of conduct is unconstitutional. It ought to be overridden by the provisions made for the applicants within the Constitution's Bill of Rights. Firstly, I will be stating how under Section 2 of the Constitution, which speaks to the supremacy of the Bill of Rights and establishing why the school's code of conduct is one of an unconstitutional nature, and then in the submission I will also be referring to why in its unconstitutionality this court ought to declare it invalid. So as stated in Section 2 of this Constitution, to deal with the supremacy of the Constitution is the supreme law of the land. Law or conduct inconsistent with it is invalid, and obligations imposed by it must be fulfilled. Now, I would like to submit argumentation to this court that speak to the unconstitutional nature of the school's code of conduct. As my co-counsel and my learned colleague presented to this court, it infringes on rights that this court ought to hold in the highest regards, the right to dignity and the right to equality. But what I would like to do is refer this court's attention to Section 15 of the Constitution, which speaks to the allocation of the ability to express the specific religious views as held by the respondent. And we would like to recognize the respondent's ability to express their religious beliefs. However, as stated in Section 3 of Section 15 in subsection B, that the recognition in terms of paragraph A must be consistent with the section and other provisions of the Constitution. And then again, I would like to refer to the court's attention to Section 31 of the Constitution, which speaks to when religious communities and when religious schools, such as the respondents, are validated and are viewed legitimate. And in subsection 2, it states that the rights in subsection 1 must be exercised in a manner may not be exercised in a manner inconsistent with any provision of the Bill of Rights. What we submit to this honourable court is that the respondent's code of conduct is in clear violation of the provisions afforded to them as a religious school, because they actively violate the rights of equality and the rights of dignity afforded to the applicant.
Sorry, may I interrupt you for a second? I'm possibly going to take you out of your stride, but I'm sure you'll come back to it. I assume that you would like all rights to be adhered to and to be honoured by the school.
Yes, my Justice.
And there are also many different grounds, or several different grounds of discrimination recognised in Section 9, not only sexual orientation.
Yes, my Justice.
Now, my colleague, my brother-in-law here on the right, mentioned the rule that the girls can also not take a 40-year-old male partner to
yes.
the...
Yes, my Justice.
Isn't that discrimination on the basis of age? Is age one of the grounds in 9, and wouldn't that be discrimination on the basis of age?
Well, my Justice, age is not a grounds on which you can legitimately discriminate against anyone. However, in this instance, what we ought to have noted is that many of the students that would be attending this matric dance might not yet, or are probably still minors. In the case of the applicant, she is still 17. Therefore, the court has an obligation, as stated in Section 28 of the Constitution, to look after the best interests of the child. And we submit that the age restriction placed on the bringing of dates to this dance is in line with that, because it is not within a child's best interests to engage within a relationship of a romantic or sexual nature, as might be facilitated by her bringing them as a date to the matric dance.
Is a romantic or a sexual relationship a prerequisite to go to the matric dance?
Well, my Justice, we say that it might...
Are you alleging that all of the people who come there will afterwards go and be romantic and perhaps even sexual?
No, my Justice, that's not what we submit. However...
One, bring your best friend to the matric dance if it's
Well, my Justice, that might be the instance in several cases. However, there is the ability for there to be the presence of a romantic or sexual relationship between dates that we think we
You mean
ought
right
to-
there at the dance or later?
Well, later, or maybe even there at the dance, my Justice. We think that,
If somebody wants to bring their father,
my Justice...
who's 50,
My Justice, again, then we say it's not suited to the occasion of a matric dance, and that the matric dance is one by nature of the perception of a date. It's someone that you are able to enjoy the dance with in a nature different to a family relationship and maybe even a friendship relationship, as the way that a matric dance date has been perceived in common.
Council, if you can, what do you say? What is your attitude when the school says you've been given the code of conduct, you read the code of conduct, and this is a once-off thing, and the school says this is a privilege and not a right? What would your response be to that?
Well, my Justice, in regards to it as a privilege, not a right, even if it is a privilege, the Constitution says that the equal allocation of privilege is something that ought to be upheld. So even if it is just disregarding a privilege, it is still in violation of her right to equality. And then with regards to the fact that it's for one right only, my co-counsel dealt extensively with the fact that the psychological derogation of character and the perpetuation of cycles of oppression would mean that the applicant would not just be affected by this limit for one night of her life. It would extend past just this one night, but it would also teach students by setting a precedent that this is right behavior and that the homosexual community ought to be disregarded their rights. In terms of signing the Code of Conduct, we refer to the case of Barcasia versus Napier, when it was said that consent to a contract can be declared invalid if the contract itself is unconstitutional. And I have submitted to this court that it is unconstitutional in nature. But also, when she signed the Code of Conduct, she was only in grade 8. She might not have understood her sexual orientation at the time, but she also might not have understood the gravitas of the infringement on her right to dignity. So we submit that she still ought to be allowed to not be held binding by that contract, if it answers your Justice's question.
Was it not the guardian who signed the contract?
It was a guardian, my Justice, and that was because the applicant was not of the age by which she could sign it herself. And again, we submit that as it was not the applicant who expressed a willingness to comply with that Code of Conduct, the school and the respondent is not justified in their expectation that she has the obligation to comply with it, because she hasn't herself explicitly said that she was going to, if that answers your Justice's question. And
Council, from my side, I want to ask you, I assume you're aware that there are many single-sex schools in South Africa, all boys or all girls schools. Mm-hmm. Is that correct?
Yes, my Justice.
I may even be right in assuming that at this event there are some such schools represented here as well.
Yes, my Justice. I come from such a
Do you
school.
think that is constitutional for us to say that a boy cannot go to a particular girls' school or a girl can't go to a particular all-boys school?
Well, my Justice, we say that it is constitutional in the regards that there is, as long as there is another alternative made available to that particular male or that particular female wishing to attend the other dance. In instances where you have single-sex schools, it's not created for a means through which to offend someone of the opposite gender, but in an extent rather to uplift them in the sense of a single-sex girls' school. It might be an instance where they might want to build a community through which they can overcome the previous oppression faced by females within society, which they are justified to do so under the equality section of the Constitution.
You're the counsel for what's her name, Cara?
Clara.
You were instructed by her sister Michelle, is it not?
We were instructed by her girlfriend's sister, who is a lawyer, Michelle.
Yes. And you're the counsel and the instructing attorney is Michelle.
Yes.
Now, was the guardian involved in any of this? Do you guys have locus standi to be before this court? Or have I skipped that part in my study of the documents and the background facts?
Well, my Justice, it's not stated within the facts whether or not the applicant's guardian was involved within this process. However, we submit that hypothetically, the guardians must have been.
All right, we will assume for present purposes that the guardian is with you.
Okay.
I think 10 seconds to wrap up.
Okay, and it's for the aforementioned reasons that we pray that this court humbly grant the following submissions. That the applicant be allowed to attend the matric dance with a partner of her choice of gender, and that the rule be amended in the school's code of conduct, as it is unconstitutional, and we ought to protect all future learners from experiencing the same degradation of their human rights as faced by our applicant in this instance. This concludes the case for the applicant, and if it pleases the court, I would now like to take my leave.
Yes, do we have Ms. Smith now?
As the court pleases, I will be addressing the court for 12 minutes and my co-counsel will be addressing the court for 8 minutes. At the outset, the respondent respectfully points out that the applicant made the following errors in the argument. The applicant alleges that Kara's rights of dignity is being limited. And furthermore, that in terms of the Christian education case, they ruled in favor of the learner's dignity. However, in this case, we need to consider that in terms of Christian education case, the learner's dignity was being impaired for a continuous time, whereas here the learner's dignity is only being limited for one night only. If the court is satisfied, I will now continue with my own argument.
Sorry, did you say just explain the last point? You say her dignity is limited, or what do you say, for one instant only, or what?
As the court pleases, in terms of the Christian education case, the dignity was impaired for a continuous time, whereas here the dignity is being impaired for one night only.
So is that, I think, speaking for myself, I will have to think about the depth of that submission. That it is what for one night dignity would be impaired and the next day it would be restored again.
As the court pleases, the school's dignity and identity cannot be seen to be less inferior to that of her, and therefore there needs to be a weighing up of interest between that of hers and that of the school's, as required in State versus Manamela, that each case needs to be looked upon on its own merits.
So are you saying this is a weighing process between her dignity and the school's dignity?
As the court pleases,
Now,
yes.
if she brings the partner, will the school's dignity, if it is at stake at all, will that not only be impaired for one night only, or is that be a more longer-term damage to the school's dignity? If a school can have dignity, which is another question that you may have to answer, let's start there. Can a school have personal dignity, inherent human dignity, as the Constitution calls it? Is a school a human being?
As the court pleases, in the Pillay case, it was held that identity and dignity is inseparably linked. Therefore, the identity of the school could refer to the dignity of the school as well. Furthermore, we need to consider the fact that Kara will be leaving the school soon, and the rule of the school will then apply to other learners who have consented to be bound by the school's rules and regulations, and order can therefore be threatened. Furthermore, the school's identity and dignity, therefore, in that sense, will not be upheld.
Right, proceed with your argument. We'll get back to it.
The respondent will show that the High Court was correct in its ruling and its decision. The respondent's case is based on 3 alternative grounds. Firstly, the respondent denies that prohibiting the applicant from being accompanied to the matric dance amounts to discrimination as alleged or at all, but is rather in accordance with a school rule which has a clear and definite purpose. Alternatively, if the court does find that there has been discrimination, then in terms of Section 14 of the Equality Act, such discrimination is fair. Further, alternatively, if the court finds that the discrimination is unfair, then the applicant's rights have justifiably been limited in terms of Section 36 of the Constitution. I will address the Honourable Court on the matter of discrimination and its fairness in terms of Section 14.2 of the Equality Act, while my co-counsel will address the Honourable Court on the remaining grounds of fairness in terms of Section 14.3 of the Equality Act and Section 36 of the Constitution. In drafting and enforcing the school rule that allows learners to be accompanied to the matric dance only by a male partner, the school was not discriminating against Kara as alleged or at all, but was merely acting in terms of various principles of our law, which includes the following.
Counsel, can I interrupt you there? For a matric dance is a special occasion. Her schoolmate are going to come with their male partners. And if she's not allowed to bring her partner, she's going to be denied the the status and the benefit of having been at a matric dance with her partner, isn't that demeaning? Is she not being treated differently?
As the court pleases, given the fact that it is a Christian school, furthermore, it doesn't condone homosexuality, the school has accommodated her in a diversity in the sense that they're still allowing her to come to the matric dance. Furthermore, they're still allowing her to attend the school, given the fact that they know she's now a homosexual person.
But what is wrong with homosexuality?
As the court pleases, it is against the teachings and beliefs on which the Christian religion is founded. For an example, in Taylor versus Gestag, the Jewish community was allowed to excommunicate a member upon his refusal to obey their rules. And the court held that excommunication was justifiable and reasonable to protect the identity and integrity of the Jewish faith. So similarly, in this circumstance, to protect the identity and integrity of the Christian faith, furthermore, the school, excommunication therefore is justifiable by not allowing her to come to the dance with a female partner.
Council, can I just ask you on that point, why is it that we make such a clear correlation between Christianity and exclusion of sexual orientation in this case? Didn't we have an example in this country in this last week where one of the churches who used to be very conservative said we actually were in the wrong and we should accept people of all sexual orientations? And isn't it true that in many Christian denominations that link is not really made? Why do you make this link that Christianity necessarily is against people with this particular orientation?
As the court pleases, the purpose of this is to solely protect the identity and integrity of the Jewish faith. If it associates itself...
But let's, we don't want to waste your time, Ms. Smith. Listen to the question and answer directly. If I can put it in a more direct, perhaps crude way, who says same-sex relationship is against the Christian faith? Do you have authority for that?
As the court pleases, in terms of the biblical teachings and what is taught at church, it is submitted that therefore homosexuality in terms of the Christian faith is not allowed, as the court pleases.
Your authority. Okay, let's move on to the next question.
Council, may I ask you, is your code of conduct consistent with the Constitution and the South African Schools Act?
As the court pleases, in terms of the South African Schools Act, in terms of section 57, independent schools are allowed to be established, furthermore with a religious nature. Furthermore, this is also in terms of section 16 of the National Education Policy Act. However, in terms of the South African Schools Act, discrimination is not allowed only on the basis of race, and certain sections of the Schools Act doesn't directly apply to independent schools.
Council, can I ask you, isn't it true that education is about forming personality? It's not just what you learn in the classroom, it's also what you do on the sporting grounds and what you do at social functions. And isn't it true that our Constitution is underpinned by the idea that the doors of culture and learning should be opened? And those are the doors not just of the classroom, but also the doors of social interaction. And all of that goes together. And if we start saying that it's okay to discriminate in the one aspect of education, but not in other aspects, or it's okay that you shouldn't discriminate in one aspect, but you can discriminate in other aspects, are we not reducing the kind of education that we want to offer to our future citizens of the country?
As the court pleases, the school was established for a specific purpose, given a religious purpose. So it also is allowed in terms of State versus Lawrence to manifest their beliefs. In doing so, by allowing homosexuality, it will be going against its direct teachings and beliefs, which thus affects its quality of education which it delivers. In Prince versus Law of Society, it was also recognized that it must be practical to grant an exemption. In this manner, it is not practical, as she could possibly interfere with the teachings and beliefs and code of conduct on which the school is founded, furthermore causing disruption in the school, given the fact that other teachers, learners, and parents have been signed to be bound by the school code of conduct, and order can therefore be threatened.
You mentioned the word disruption now. I'm sorry, I apologize if I take it slightly out of context, but you think there will be disruption of that matric event if she arrives there with her same-sex partner?
As the court pleases, Kara's very public remarks that she has made on Facebook that she cannot wait to see the look on everyone's faces shows that there is an intent to cause disruption at the school. Furthermore, given the fact that it is a religious school, everyone has been bound.
How disruptive can the expression on people's faces be?
As the court pleases, they may not be in agreement to what is happening. Furthermore, they can protest, given the fact that they know before, if they know before the matric dance, then it can cause disruption in the school in the sense that parents can protest and demonstrate against them, allowing her to be accompanied to the
You
matric
think all
dance
of
by
that
a
will,
female
is that a
partner.
possibility? Why can't they just enjoy their own dinner with their own partners?
As the court pleases, given the fact that once again they want to protect their Christian faith, they will therefore act against it. In the cases of Pillay and the Christian education case, it was accepted that when deciding whether discrimination is fair, the centrality of a practice to a religion is relevant. If the school is to allow a girl to bring a same-sex partner to the dance, then it can possibly offend other learners, teachers, and parents who have all accepted to be bound by the school code of conduct. Furthermore, it has been accepted by both our courts and legislation that in making changes to our law, a person or body is not expected to relinquish his or her religious belief to follow the Constitution blindly without conducting an exercise of proportionality. For an example, Section 6 of the Civil Union Act allows a minister to decline to conduct a same-sex marriage upon his, as it is against his religious belief to do so. In the Christian education case, it was also recognized that granting respect for religious view does not amount to unfair treatment. Furthermore, our courts have also accepted that organizations and institutions are allowed to adopt certain exclusionary clauses which, despite being based on prohibited grounds, remain in context fair discrimination in terms of the mission for which the organization was established. Furthermore, an independent school's right to enforce an exclusionary clauses which, despite being based on prohibited grounds of discrimination, is recognized in the Department of Education's document, Rights and Responsibilities of Independent Schools. As the court.
Thank you. Thank you very much. Yes, Ms. Chetty.
As the court pleases, the respondent will demonstrate with respect that it has met all the requirements of Section 14(3) of the Equality Act and that any alleged discrimination is, in the circumstances, fair. Firstly, in terms of subsections A and B, the impact on the complainant and the impairment of her dignity must be considered. The respondent denies that there is a significant impact, if any, on the applicant by enforcing its rule. However, any such impact must be considered in the context of the school in relation to the other learners and not in a vacuum. The ease and comfort that Kara is seeking for one night cannot be held equal to asking the school to abandon its very sacredly held beliefs and teachings, which it will continue to teach after Kara leaves the school in a few months. As it was held in the case of Prince versus the Law Society, the court recognized it must be practical to grant an exemption. The school is simply asking Kara to be inconvenienced for one night only and not to relinquish her identity forever. This is seen in the fact that she is not being denied complete access to the school itself or to the dance, but merely being asked to accept a condition which has been placed upon her attendance.
But Council, may I ask you this argument about it's only one night? So if we talk about the right to dignity, isn't it so that dignity can be infringed within a few seconds by something you say to somebody else? Or it can take an hour, or it can take a few hours. Is there really a difference that one says if it's for a week or for a month? If you violate somebody's dignity, you're really telling that person, in this particular case, I don't respect you, and institutionally, you're telling the person you're not welcome here. And that can be done whether it's within a few seconds or whether it's within a week.
As the court pleases, the respondent is submitting that her dignity is not being infringed upon, but merely limited in terms of Section 36, if the discrimination is found to be unfair. As the court pleases. The applicant is alleging that her rights to equality have been violated. However, as it was held in the case of Prinsloo versus van der Linde, Kara cannot be expected to be treated just as all the other girls are, as she is different. Nevertheless, She is still being treated with equal respect and concern in that she is not being denied complete access to the school or to the dance, but merely being asked to accept a rule which has a clear and necessary purpose, as my co-counsel has already stated. Furthermore, as the courts recognized in the case of Harkson versus Lane, differentiation between parties is not a violation if the differentiation is linked to a legitimate purpose. In relation to Section 14(3)(c) and the applicant's position in society, the respondent accepts that the applicant may be part of a society which has a group of people who have been discriminated against in society. However, as it has already been shown, the respondent denies that its actions are based on discrimination.
What is the legitimate purpose that you've just mentioned? What is the legitimate purpose here?
As the court pleases, the legitimate purpose of limiting Kara's rights are to protect the integrity and dignity of the school, as the court pleases.
What about her dignity, counsel?
As the court pleases, her dignity is not being infringed but merely limited. Furthermore, her intent or the Facebook comments that she had made saying that she wants to see the look on people's faces when she attends shows an intent for disruption, and therefore the respondent cannot accept that her dignity will be infringed upon. Furthermore, the relationship between her and Joanna are only 6 months old, and therefore the respondent cannot accept that it will have significant impact on her.
You, one of the tests there in the clause that you're reading, Section 36, and it was raised by your opponents, is whether there are less restrictive means to achieve the same purpose. So let's assume that it is a legitimate purpose to retain the school's Christian ethos and value system. And let's not argue anymore about whether it is really conclusive that Christianity takes that position, but let's assume that is the purpose. Do you think there were any less restrictive, less serious measures that the school could take?
As the court pleases, according to Section 14(3)(g) and I, it is required that less restrictive and less disadvantageous means be applied, also that diversity be accommodated. In allowing Kara to attend the school itself and the matric dance, it is being accommodative of her diversity and applying less restrictive means, as the school is fully aware now of her sexual orientation, but they are not discriminating against her based on that.
But specifically around the dance, are there any less restrictive means other than to say to her, no, you cannot come with your same-sex partner?
As the court pleases, the less restrictive means being applied is that she herself is still being allowed to attend the dance.
But there were other things. I think we may be missing each other, thank you, on the less restrictive means. Could they not have said, for example, bring your same-sex partner, but forgive us if we, in Monday's classes or in the next religious tuition, again explain that the way we understand the Christian doctrine, it is against same-sex relationships. However, we do allow for the diversity in specific instances. In other words, you bring your partner, but we as a school will at an opportune moment explain what our doctrine is.
As the court pleases, this is in terms of the fact that the school is merely trying to ensure that there is no public display of Kara with her girlfriend, as this is, as previously stated, in direct contravention of beliefs of Christianity, and therefore the school does not want to show that it is condoning homosexuality in that state.
But they can make it clear the next week when they speak to the children. Or are you saying they don't want that kind of conflict to play out in public?
As the court pleases, the respondent does not need to be degraded by doing such.
Why are you assuming that Kara is going to make a public display of her sexual orientation? She's just brought a friend, it could be a sister, to accompany her to a matric dance.
As the court pleases, this leads back to her very public remarks on Facebook, where she states she cannot wait to see the look on people's faces when she
What
comes
you're
in
saying
with
is
her girlfriend.
this is actually an act of activism on her side. She is actually challenging the school. And perhaps what you would say in response to my question is that whether there's romance or sex or anything else involved or not, but a matric dance is essentially a date, and young people see it like that. Is that what you're saying? And the school would not like to see people dating somebody from the same sex?
As the court pleases, not exactly in that sense, but more it's the public display. It's basically her bringing her female partner, whether they are going to act in a romantic manner or so ever. It's there to show that she is homosexual. And in that manner, the school cannot accept that they are now going to have a hand in assisting her to publicly...
So the school, now link this to your previous remarks, that the school is already very tolerant by allowing her to be at the school, but as long as she doesn't show it that she's homosexual. She must be there always, but be quiet. When other girls talk about their dates, about their experiences, about who invited them to go to whatever, she must always be quiet. She may be homosexual as long as she does nothing about it. Is that the school's policy?
As the court pleases, this is merely about her displaying her relationship itself with a homosexual person in terms of the matric dance. The school is tolerant in the manner that they are aware of her sexual orientation, but as it is one of the founding beliefs of Christianity is tolerance, they are acting in a manner that is tolerant by accepting her and showing others that although they may not condone a
I'm
certain...
very happy that you reached that point about the tolerance in Christianity.
As the court pleases, the respondent therefore respectfully submits that it is not acting in a manner that is discriminatory, and if there is discrimination, found that the discrimination is fair. If, however, the Honourable Court finds the discrimination to be unfair, then the respondent submits that the discrimination is necessary and Kara's rights have been justifiably limited in terms of Section 36 of our Constitution. Therefore, although Kara does have certain rights, her rights must be weighed in regard to the learners, teachers, and the school itself. The weighing up of competing interests is also very important in determining the extent of the limitation. This has been made clear in public cases which include De Reyk versus the Director of Public Prosecutions and Sitau versus Garbas and others. In the current matter, Kara's rights to be comfortable for one night must be weighed against the rights of the other learners to be educated constructively in an environment that they have chosen for a specific purpose. The respondent therefore submits that any limitation on Kara's rights are justifiably limited in terms of Section 36 of the Constitution. If the court is satisfied, the respondent respectfully prays for an order confirming the judgment of the quota quo with costs, if it pleases the court.
My justices, as it pleases the court, I have two submissions of rebuttal to bring forward in response to the respondent's case. The first one will deal with the discipline that will be provided for within the instance of the matric dance, and the last one will deal with whether or not the respondent's religious rights ought to be upheld. In regards to discipline at the matric dance, we say that the extension of the school's code of conduct in this regard is unnecessary because the disruption that the applicant would cause, if any, by bringing a same-sex partner is of negligible value. It must be noted here that the applicant is openly gay and she has been at the school for a long time, presumably 5 years. We presume that by now, at least by merit of her being openly gay, people will know of her sexual orientation by the fact that she's taken the school to court. It'll be a public event and people know that she is a lesbian. It'll therefore not come as a surprise that she brings a partner of the same sex. Therefore, the disruption would not be a surprise and it would not be extreme because it is expected. And lastly, we'd like to submit that there are less restrictive means through which to ensure discipline at this event, which means that the respondent taking away the applicant's rights is in disregard of Section 36 of the Constitution. The less restrictive means that we would like to refer to would be if discipline is the issue, then the school ought to have greater presence of teachers or of security at the dance, so if a dispute or if disruption was happened, someone could be apprehended, and disciplinary measures such as a school hearing or such as detention would be imposed on the individual that caused discipline. Those limitations and those infringements on an individual's dignity are justified, as schools do enact disciplinary measures all the time. It is not necessary to go to the extreme of stripping the applicants of a right to dignity and a right to equality for this one night. And we do not accept that it is just one night that the effects will be felt. The long-term impact of her dignity being taken away will be one that will stand with Kara for the rest of her life, because the matric dance is an event that you remember very, very clearly because of the gravitas of the dance. And then just lastly, we'd like like to say that the school, in fact, has not accommodated diversity because they're not allowing Cara to be explicit and to express her homosexual identity. Rather, they want her to comply with one of heterosexuality. And this ultimately concludes the applicant's case, and as it pleases the court, I wish to take my leave.
Thank you, Ms. Rankin. I think if there are no further questions from this side, I wish to thank you and all other counsel for your arguments, which will be extremely useful in the consideration and determination of this very complex matter. The court cannot give a judgment right now, as you will understand from the nature of your arguments, and therefore judgment is reserved and the court adjourns.
It was an amazing experience given the fact that very few advocates and attorneys get to appear in this court, the highest court of the land. I'm humbled by this amazing opportunity and experience, which I hope to in future get to experience again. The case was difficult, the panel was tough, but we managed to pull it through, and we hope that the judges remain on our side.
I liked the banter that we had. that was kind of nice. I hope it didn't come across as disrespect, because I definitely do respect them. So they were very nice, they were very genuine, and I have so much respect and honour for them.
The entire journey of being through this moot court competition has really, really taught us a lot. We've dug deeper into our constitution and found out so much about our country, that it's rich in heritage, and the rulings and the judicial system is just brilliant.
Speaking here is like one of the biggest honours I've ever had. And I mean, Clara and I coming into this competition, our end goal was to reach the Constitutional Court and get to speak here. And it is almost undescribable, just the feeling you get when you speak here. I mean, we stood in the same place. People who are probably very important have stood before and we've spoken. So regardless of how the case went, I think I was a lot less nervous.
We take all kinds of things into account, which makes it more or less difficult for one side. And this was a very difficult process. We talked about it, but we also gave you scores, which you, I think, could see. I'm not sure, but you got specific marks for specific categories. And when all of these are added up, unless somebody's calculator made a mistake, in which case this court will simply order that the mistake is legal and valid, and therefore not a mistake. The result is by a difference of only 0.25%. There is a 0.25% difference between the two sides, so by 0.25% the applicants win. And the court adjourns.